Thank you very much, Marty, for the introduction. Very, very much appreciated. Thank you to each and every one of you for coming to our presentation here today. We appreciate you being here. Our goal, our hope is that we can both entertain as well as inform. So if you're going to come and spend time, we think that that's our obligation, because as trial lawyers, that's also something we think is our obligation to a jury. If we're going to be in front of them on a patent case with specification and claims and scientific words for a month, you can't just inform. At some point, you need to also, in part, entertain, and we'll talk about that. But as I say thank you for coming, I also want to extend my thanks to you, Dr. Agarwal, for the invitation for us to be here at your magnificent conference. We admire what you have achieved in the history of this conference. We have enjoyed being here. We have met all kinds of people. You have known all of my partners, and Sharon and Jeff and Brian and Matt and Marty. We have our cards with our Hindi on it that we have extended to people, and I've had numerous comments. And I have made the comment more than once when I have someone has made a comment back and said the reason we have done that is because we do not think we're the most important people in the world. We think you are. And we're very excited to be here and be with you. And I say that sincerely. We happen to be, so I'll just leave it at that. So let me say, this is the title of what I'm talking about. You've seen the title. How to Move $1 billion Across the Table at a 10-to-1 Return Without Trial or Appeal. So what Marty just spoke about were numerous cases, and there are, fortunately, in our firm, many others, and I'm very proud to be associated with these trial lawyers and individuals here who have gone to trial in patent cases and can speak about them. But we're here also talking about patent monetization. And there's all kinds of ways that patents are monetized, and there's ways to monetize them economically short of trial or appeal, fortunately. And I'm going to talk about that here in some depth. But I'm going to talk about how. And I will suggest that what I have heard in the 8 days that I have been here as a part of the conference, that most of the presentations have been in-depth, many times about the law, or as is more than appropriate, or they have been in-depth in some technical way or in some other way. What I'm going to try to do is take two cases where in those two cases we moved $1 billion and talk about them from more pulling out some lessons learned and actually attempt to say, how does one go about doing that? And so that's the goal. And it's a bit of an audacious title, and you will tell me at the end whether I achieve the result of making good on the promise of this title. We're going to move fast through a lot of things, and I'll come to that in a second. So first of all, patents are the intersection of engineering and the law, right? What is engineering? This magnificent profession that has enormous respect all over the world, enormous respect in India and the U.S. and all of our great engineering schools, and it is the art of precision. Irrespective of what aspect of engineering is, it is the art of precision, and it is an art. Yes, it is a science, but it is an art form at its deepest roots. And what is the law? The law is the art of persuasion. How do we go about persuading? And we study how we can become better presenters, how we can use tools, how we can persuade. That's the great art of the law that we as trial lawyers study and critique ourselves and critique each other and subject ourselves to harsh critiques to make our presentation better in front of a jury. Something has happened in patent litigation. Marty gave you a broad overview, that tipping point, okay, when trial lawyers got into the law. And right in the mid-90s, and we were there at that tipping point, and no one individual creates a tipping point. Lots of things come together to create a tipping point at a moment in time in society, and possibly you're lucky enough to be at that. And we were as trial lawyers. But what do trial lawyers do when they get in to a case? And then trial lawyers get in over a period of time where patent litigation had been done exclusively by patent prosecution firms that were almost all male, and that was very much in the U.S. a kind of gentleman's argument about licenses, but no more. Trial lawyers got in. What do trial lawyers do? They expand damage theories. right? Because they have some imaginations about how they want to go about trying their lawsuits. And so damage theories, when trial lawyers get involved, expand. And what's happened in the United States? In response to that trend, there is something new. It is no longer two circles. It is no longer engineering and the law. There is a new circle that is totally, totally on the map. In patent litigation in the U.S., it is deeply embedded. It is brand new within the last 3 or 4 years, and it will, in my view, have an impact on how patents are valued over the entire world. Because people look to the law that's coming out of the Federal Circuit, as they should. I think it's a magnificent court, and it's deeply reasoned and deeply thought out. But I also think that it has, what has occurred in the art of quantification is very significant. Now, I have a seminar that my partners here are aware of that I give for a half a day, full day, and sometimes longer. And one of the things is to talk in depth about the art of quantification. I don't have time. I'm not going to do it. Here's a 10-page article, and here's a 2-page handout. And it makes good on what I just said, and here are the 10 cases that are spoken about in depth in this article, and it's all here for you to pick up following the presentation, or I may hand it out. But I want to say, econometrics, the art of quantification, I'm going to talk about how it's dealt with in a case in front of potentially a jury and also a judge, but there is now a new body of law within the last 6 or 7 years that the Federal Circuit has laid out in these 10 cases, and it's there. And as I say, to go through that, that would be a minimum of an hour to have that kind of conversation. I could do that, but we're not going to do that here. What do we know about juries? We know a ton of things about juries. And I'll just say 3. We know they make decisions on a 10th grade level. They make the most practical decisions possible, and they make decisions based on 30% of the information they hear from the witness stand. So let's just say, for example, take the last point. If we're trying a lawsuit, and Marty's trying the case with Matt on behalf of Honeywell against JVC, and if they practice their presentation, and they subject themselves to mock juries, and they subject themselves to their partners, and they subject their demonstrative evidence to critique, and the other side doesn't. And they do a lot of other things that the other side doesn't do in the art of persuasion. And if possible, the jury makes a decision based on 80% of their information and 30% of the opposition's information. Look what just happened. Were they a better speaker? Did they have a nicer suit? Why did they win? They didn't win because they made a better argument. They won because the jury made a decision based on their information. Because it was presented in a way that they could digest. Now, people get all alarmed about juries in the U.S. and they say, oh my gosh, they make a decision based on the 10th grade level. And I say, have you put a group of 10th graders in a room and argued a case to them and seen them make a decision lately? Try it. You'd be amazed. You'd be shocked, frankly, at the depth of the decision. Now, I don't think we don't have any judges in the room, but I would say it even if they were. Guess what? Individual judges, schooled in science or not, because of the numbers of things on their calendar, make decisions on approximately that level. It's a great misunderstanding, in my view, about patent law in the U.S., and I've heard it somewhat here, and that's the influence of juries. Yes, there's a jury looming. 95% of cases settle. 2 most important things that occur in a patent case are the Markman hearing, construing of the claims, which we all know and I won't talk about, and the summary judgment hearings that are typically motions by both sides. Both sides are trying to win summary judgment to a judge. Both Markman to a judge, summary judgment to a judge. Case settles either many times after that, before trial, the 95%. What are we doing in the U.S.? We're trying patent cases to judges. Judges, in our minds, are just like juries. They need complexity simplified and see if we can get them to make a decision based on 80% of our information, 30% of the other side's, and see what happens to the odds, right? So in an Intergraph case, we represent a company called Intergraph. Intergraph is the largest company in Alabama. It's a $1 billion company. They had the fastest processor in the world for 3 months. And today they're a software company, and they had some patents that came out of that. I'm going to talk about this from the how to move $1 billion. So we sued Dell, Hewlett-Packard, Gateway. Matt and I were very heavily involved in this. We were co-counsel here, so he will be in pain listening to some of these stories. But that's the $500 million. These are the licenses that are public, other confidential. There's 3 kinds of patents. I want to do a little orientation so we all have the same definitions of what we're talking about. Incremental patents, the great majority. No, it's not the great majority. It's 99.9% of all patents are incremental. They're distinct enough from the prior art to be patentable, and that's it. Possibly, you'll run into a foundational patent. I don't think I'll ever have the opportunity to represent anybody in a pioneering patent. Why? Because typically if a pioneering patent is so far advanced, by the time it's implemented, the protection has run out. But I heard a comment downstairs this past week, and that is, well, there's incremental patents, but then foundational patents typically come out of universities. We represent a lot of universities. We've seen a lot of patents in our day in our firm. I've never seen a foundational patent walk in the door. Almost every single inventor that walks in the door thinks he or she has a foundational patent, and they walk in telling you that. Guess what? It's just not the case. How? How does an incremental patent become a foundational patent? I heard a comment downstairs this morning. Don't listen to the lawyers too much in evaluating the patent. You've got to go to the technical people. Couldn't agree more. Couldn't agree more. But I'm going to posit and make a comment. The way in which an incremental patent becomes a foundational patent is if a trial lawyer has the guts and the imagination to attempt to blow life into that patent and to make it a foundational patent. Does that trial lawyer do it alone? Not anywhere close. That trial lawyer does it with experts who are not just of ordinary skill in the art, but are of extraordinary skill in the art, and with the inventor. And it's a combination of those 3 in a team, and maybe there's more on that team than just 3 people, who are going to look at a patent and see if they can blow life together into the patent to make it a foundational patent. What does a trial lawyer do? My daughter said to me, she said, when she was about 11, she said, Dad, what do you do for a living? I said, what I do is I ask lots of dumb questions. She said, no, Dad, like, what do you do? How do you make money? She said, I know you do that. I mean, I know you do that. No, honey, I said, that's what I do all day long. I said, you just ask dumb questions. She said, God, you can get paid for that? That's amazing. You can get paid for doing that. But I mean that, and I'm going to try to play that out, because what's the one question that's on the jury's mind? What's the one question in quantification that's on the judge's mind? And what's the one question that we all forget because we're so buried in the prior art? We're so buried in the claim language and all the claims. What difference does it make? What difference does it really make? Can it be quantified? Can it be described? And so can we constantly ask that question? And the hundreds of questions that follow it about each and every element of the claim, and on and on. So here's an example. Here's an independent claim, first independent claim, 3 patents, all in the same spec in the Intergraph case. Every single one of these elements, and we labeled the elements ourselves here, so you can even have a conversation, 1 A, B, C, the sub 1 E, etc. And every single element was old. We also tell a joke in the firm that patent lawyers, many times, rarely understand what was invented. And inventors, many times, don't understand what was patented. In this case, shockingly, it took us a year because we were convinced we were dumb, and that's always the way I start out. It took us a year to figure out that the patent lawyer and the inventor didn't know what was patented or invented. And every single, and Matt laughs, I heard that laugh because he knows it's true, he remembers the pain. And every single one of these elements was old. And the client was spending money and paying us, and it was old. And it was there, and we could see it in the prior art, and on and on and on and on and on. Through all kinds of conversations, this element became worth $500 million. Because lawyers, clients, experts, and inventors stayed in a room and had a Socratic conversation for a long time. Not a day, and not a week, and not a month. And we found out what this meant. And I'm not going to go into it in great depth, Okay, I'm not going to. So some of this stuff I'm not going to drill down on because I'm kind of assuming, and frankly, this is a PhD audience. This is not a 10th grade audience, so I'm not going to give this presentation to 10th graders. It would take much longer to do it if we were doing this with a mock jury group. So, you know, let me try to bring this alive, right? System tags. Right through. Here's a CPU, a computer, cache, memory, input-output devices, right through. Cache data storage mode every single time it CPU, brains of the computer, writes to the cache. It must, by definition, write to main memory. That's right through. That's what it does. It's yellow. Copy back. CPU, brains, when it writes to the cache, that's all it does. It never writes through to main memory. What did Howard Sachs do? At 2 a.m. in the morning, his wife had made chocolate chip cookies. She could still smell them. He got up at 7, went to work every day, came home at 9. He had dinner, went to bed. He smelled the chocolate chip cookies. He got up, he had a warm glass of milk, and he thought, aha, I now know how to make the world yellow and green at the same time. And he went to the office. There's a whole bunch more detail behind that, which I won't go into, and he made the world yellow and green at the same time. And so now what could happen? We had page-based system tags. That's the claim element that we talked about way back when, multiple cache data storage modes at the same time. Take your whole case and be able to put it on one picture and have it up all the time in front of a jury so you can refer to it. So without the invention, let's watch it. Here's a demo, demonstrative evidence of write-through, right? It created pictures like this, they move like this, and there's waiting because when the CPU is writing to cache and then through to main memory, if there's something else on the bus, it has to wait, right? It's slower. That's why we had images like this. That's why they move like this. 3M and a gazillion others in the world paid $300,000 for those computers, and they took us to the moon. And they had more, and they had far less capacity than what we have on our handhelds, right? With the invention, demonstrative. All this is demonstrative only. We just created images like this. They move like this. Why? Because you got copy back working with write through at the same time. Faster, better images, right? So now what I'm going to do is I'm going to show you real evidence, not demonstrative evidence. Put the demonstrative evidence side by side. But now I'm going to do something different. It's going to be only time for about 5 minutes, 4 minutes actually, that there's sound. You've all been a great audience. You haven't interrupted or thrown things or hollered. But during this, you'll be tempted to talk, and I'll ask you not to. Because what I'm now playing for you are the results of an expert who we hired to answer the question, what difference does it make? So when the expert reports go in, and you put in the expert report with volumes on infringement, and then they put their report in on invalidity and show you why the patent's invalid, and then you respond 30 days later, no, it's valid, and they respond, no, they don't infringe. We did something brand new in this case. We put an expert report in on what difference does it make? What's the quality of the invention? And so why did we do that? For a bunch of reasons, but we hired an individual, Carnegie Mellon, Princeton, Stanford, and he wrote an expert report that he could publish in any peer-reviewed journal in the world that stood about this high by way of the data. We set up our own skunk works. We had a building. We had 3 people working for him. And we did it for a whole bunch of reasons because we knew we were going to need to do that in order to drive a result. What I'm going to show you at 3 minutes is a snippet of the real evidence from that expert report. What did it do for us? When you sue Hewlett-Packard, pick them as an example, Dell, Gateway, all the rest. You sue Hewlett-Packard, guess what? They don't want to talk to me. I want to go talk to their board of directors and tell them why they ought to pay, right? This would be a really good deal. I'm going to give you a deal. Pay Intergraph because here you're going to lose at trial. Guess what? I can't get in there, right? I'm persona non grata. But if I put in this expert report and it's 2 months away from trial, what does the other lawyer have to do? One, try to get a continuance to see if he can write a rebuttal report. Judge won't give a continuance. We're going to trial.